The first major test of the Supreme Court's role in relation to the political branches came in the summer of 1793. The French Revolution was in a phase called the Reign of Terror, during which about 40,000 people were murdered or executed, including on the infamous guillotine. Revolutionary France was at war with England and other European monarchies. This situation created serious diplomatic problems for the fledgling United States. France had assisted the Americans in their revolution against England. Indeed, the American Revolution would have failed without French help. In 1778, the United States had entered into a treaty of alliance with France, declaring that either nation would come to the other's aid if attacked by England. The Reign of Terror, however, shocked both the Americans and other Europeans. Further, the United States was a relatively small nation, both in territory and in military and other resources. The former colonies that now comprised the United States were surrounded by territories still controlled by England, France, and Spain. Aligning with France at this moment could prove an existential threat to the young nation. President Washington and others in his cabinet, with resistance from Secretary of State Thomas Jefferson, argued that France's current war with England was initiated by France, not defensive, so that the Treaty of Alliance did not apply. The French ambassador to the United States, Edmond Charles Genet, also known as Citizen Genet, arrived in Charleston, South Carolina on April 8, 1793. His subsequent actions came to be called the Citizen Genet Affair. He should have traveled to Philadelphia, then the nation's capital, to present himself to President Washington. But he remained in Charleston to recruit privateer ships to raid British shipping along the American coast and militia troops to fight against the Spanish in Florida. He was received enthusiastically in South Carolina, and his privateering ships, the Republicain, the Anti-George, the Sans-Culotte, and the Citizen Genet, began to take British ships. On April 22, 1793, President Washington issued a neutrality proclamation, declaring that the United States would continue friendly relations with both France and England. The neutrality proclamation stated that whosoever of the citizens of the United States shall render himself liable to punishment or forfeiture under the law of nations by committing, aiding, or abetting hostilities against any of the said powers, or by carrying to any of them those articles which are deemed contraband by the modern usage of nations, will not receive the protection of the United States against such punishment or forfeiture. And further, that I have given instructions to those officers to whom it belongs to cause prosecutions to be instituted against all persons who shall, within the cognizance of the courts of the United States, violate the law of nations with respect to the powers at war or any of them. This touched off the fascinating debate about whether the proclamation was constitutional. The Federalists, represented again by Alexander Hamilton, argued that it was a proper exercise of the president's war powers. The Jeffersonian Republicans, represented in a series of essays by James Madison, argued that the proclamation was the act of a monarch rather than a proper exercise of presidential power under the Constitution. After a series of cabinet meetings, President Washington instructed Secretary of State Jefferson to send a list of questions to the Supreme Court about the United States' responsibilities under the Treaty of Alliance and international law. Jefferson noted in the letter that the President would therefore be much relieved if he found himself free to refer questions of this description to the opinions of the judges of the Supreme Court of the U.S., whose knowledge of the subject would secure us against errors dangerous to the peace of the U.S., and their authority ensure the respect of all parties. The Supreme Court responded in a letter dated August 8, 1793, signed by each of the sitting justices except William Cushing, who was not present for the summer 1793 session. The letter stated that the lines of separation drawn by the Constitution between the three departments of government, there being in certain respects checks on each other, and our being judges of a court of last resort, are considerations which afford strong arguments against the propriety of our extrajudicially deciding the questions alluded to, especially as the power given by the Constitution to the President of calling on the heads of departments for opinions seems to have been purposely as well as expressly limited to executive departments. The Court's 1793 letter established a precedent against giving advisory opinions. As the Court's letter suggested, the antipathy to advisory opinions is tied to questions about the proper role of the federal judiciary in our constitutional republic. In subsequent jurisprudence, the reluctance to give advisory opinions often ties into the case or controversy requirement as it plays out in the doctrines of standing, ripeness, and mootness.